Good morning, everybody. Welcome to our Percolator breakfast, virtual breakfast meeting. Today is Friday, the 15th of January. We're halfway through the month, and today's Percolator is sponsored by Center State. This week, Gerald Cioci, he's a real estate and bankruptcy lawyer. He's going to talk about those topics with us today. So go ahead, Gerald.
Thank you. Good morning, Chamber. As Therese mentioned, I am a real estate and bankruptcy attorney. I've been doing this now for God knows almost 30 years, and the time has really flown since I graduated law school until now, but it has. And, you know, people look at bankruptcy with a lot of trepidation, and it's a fearful, for them outcome. It's an embarrassment to some people. It's, a shameful process to some people, and it really shouldn't be. And bankruptcy is really a means to protect yourself and your family when you have bills to pay and not enough money to pay them. And unfortunately, right now, due to COVID, we're seeing a spike in bankruptcies. It's estimated now that about 40% of the businesses here at the Jersey Shore are going to be gone by the time the COVID crisis is over. And that's a lot of people who lost, investments in businesses. They've lost investments in their portfolio. They've lost a lot of money through a lot of different mechanisms to try to fund their business, keep it going. And what's the end game for these folks? Well, bankruptcy can be a resource for them. It can be a means and a way out when the pressure starts to build and you have creditors who are hounding you for money that you quite frankly do not have at the present time. The federal government designed bankruptcy protection to actually give you the absolute right to meet these obligations through another process. Instead of paying them off financially, what you're doing is you're having a judicial process put into place to protect you from those creditors and wipe out that debt. Now, there are two chapters that people normally file in bankruptcy. The two consumer chapters are Chapter 7 and Chapter 13. Actually, 5 chapters in bankruptcy, but we're going to focus on the two consumer chapters because those are probably the most applicable for us here in Monmouth Regional Chamber of Commerce. The two chapters are Chapter 7 and Chapter 13. One of the biggest misconceptions of bankruptcy is that, well, if I file bankruptcy, I'm going to lose my house, I'm going to lose my car, I'm going to lose my retirement plan. You're not. The government has designed the process to allow you to keep those things, not leave you destitute and on the street, but give you absolutely an opportunity to get a fresh start or start over. So bankruptcy does have a lot of positives to it. It's actually, for some people, a very happy outcome because they had all the pressure of debt, lawsuits, collection firms, things like that, and we're relieving that pressure from them and giving them an opportunity to go forward now with their lives and build up themselves again. So keep that in mind. It shouldn't be a stigma about bankruptcy. It should actually be considered to be, believe it or not, a happy outcome when it's over. Now, as I mentioned earlier, there are two chapters in bankruptcy. There's Chapter 7 and there's Chapter 13. And a Chapter 7 bankruptcy is pretty much what they call a straight bankruptcy. That's a bankruptcy where we meet. I go over information from you. I find out about your assets, your liabilities, and what I'm trying to do is package up your debts into a petition, submit that petition to the court, and ask the court to wipe out your debt and give you a fresh start. You all the debt's wiped out, or the most of the debt's wiped out, and you don't have this pressure of the creditors on you any longer. A Chapter 13 bankruptcy is a little bit different. That's a payment plan bankruptcy, and I'm going to discuss the differences of that in a second. But in a Chapter 13 bankruptcy, we're actually taking your debt, we're submitting the debt to the court, and we're asking the court to allow you to pay back all or a portion of what you owe over a period of 3 to 5 years. And I'll get into that part of it in a second also. Now, in bankruptcy, in a Chapter 7, what I'm looking to do for people is to determine whether or not they have income which is below the threshold that's required for a Chapter 7 bankruptcy, and assets which I can protect in the Chapter 7 bankruptcy. The state of New Jersey and the federal government both give you what they call exemptions, meaning that's a tool you can use to protect property. So for example, in a Chapter 7 bankruptcy, I can actually protect about $25,000 of equity in your home. And with other exemptions applied to that, a little bit more. In a Chapter 7 bankruptcy, I can protect all the equity you have in your car, depending on how you use those exemptions. I can protect your household goods. I can protect your furnishings. I can protect your IRA and pension plan in a Chapter 7 bankruptcy. So you do have rights in bankruptcy law, and you do have protections in bankruptcy law that creditors cannot get after. The type of debts we can discharge in a Chapter 7 bankruptcy are basically credit card debts, loans that are not secured by property that you want to retain. And we could also just take care of medical debts. We could take care of tax debt. We can take care of fines that you may owe the state of New Jersey. All those things are dischargeable in a Chapter 7 bankruptcy. Now, with respect to Chapter 7 bankruptcy, the one thing I can't discharge is a student loan. It is easier for a camel to pass through the eye of a needle than to get a student loan discharged in bankruptcy anymore. You just can't get it done. So if you have a Chapter 7 bankruptcy or even a Chapter 13 bankruptcy and you have student loans, those are not going to be dischargeable. But if you have federal tax debt and that tax debt is greater than 3 years old, I can discharge that in a Chapter 7 bankruptcy. The same with fines that you may owe to the state for, let's say, motor vehicle violations, things like that, I can also get those discharged in a Chapter 7 bankruptcy. Now, there are limitations on how much debt you can have for a Chapter 7 bankruptcy. There's also limitations on how much income you can have, but the income test varies by the amount of people you have living in your household. So for a single person, the income threshold is different than somebody who has a family of 3 or 4 people in the household. But I'm not going to get lost in minutiae. I don't have that much time today to talk about that.
Okay.
One of the things we evaluate when you come and see us is whether or not you qualify for bankruptcy based upon those tests. In general, if you have income which is greater than, expenses which are greater than your assets and your income, you generally qualify for a bankruptcy, whether it be a Chapter 7 or a Chapter 13. A Chapter 13 bankruptcy is different. That's more of a payment plan bankruptcy. And what we do in a Chapter 13 bankruptcy is twofold. Number one, maybe you have income which is greater than your monthly expenses, or you have income greater than the threshold allowed for you to file a Chapter 7 bankruptcy. We would use a Chapter 13 bankruptcy in that instance. You may also have a secured asset, like a mortgage or a car payment, which you've fallen behind on. Well, a Chapter 13 bankruptcy can keep you in your house, avoid foreclosure, and allow you to pay back the arrears to your lender over a period of 3 to 5 years. We do a lot of Chapter 13 bankruptcies for people who are facing foreclosure and sheriff's sale. And unfortunately, we're going to see a lot more of that now because a lot of people fell behind their mortgages due to COVID. And even though there's a moratorium on this, that's going to be lifted as soon as the governor decides that the state of emergency is lifted. So we're going to see a spike in that. But I've actually filed bankruptcies the day people had foreclosure sales, with the court, and I've been able to stop that and keep them in their homes. So there's always an option. There's always something we can do to keep you in your home, and Chapter 13 is one of those options. Now, in a Chapter 13 bankruptcy, as I said before, we're paying back part of what we owe, sometimes all of what we owe. If you have a secured debt, a mortgage on a house, I have to pay back those arrears on your first mortgage at 100%. But let's say you have 2 mortgages on the house, okay? In a Chapter 13 bankruptcy, if you don't have equity in that property that's going to be equal to or is exceeded by the amount of the second mortgage, I can actually do something called cram down. And what a cram down is basically we're knocking down the second mortgage, the amount of principal that you owe on that loan, to what the amount of equity is left in the house. If there is no equity in the house, that gets wiped out sometimes completely. So you could wipe out a second mortgage in a Chapter 13 bankruptcy, and you can keep your property and stay in it and make the arrears payments on the first mortgage. So in a Chapter 13, our goal again is to try to figure out whether or not we have the income to fund what they call a plan. A Chapter 13 bankruptcy plan is a plan that has to be submitted to the court where I'm paying back the arrears on your secured debt over 3 to 5 years. Depending upon your income and your assets, I may or may not be paying back your unsecured debt. Usually, we're paying back some portion of your unsecured debt in a Chapter 13 bankruptcy. Unsecured debt is exactly that. That's a doctor bill, that's a credit card bill, that's a loan that you may have taken out personally but is not secured by any property. That could be even a tax loan, okay? It all depends upon the type of debt, but if it's unsecured debt, we're going to pay back part of it, sometimes maybe none of it, depending upon your circumstances. But the main thing is we're keeping you in your house. And it gives you an opportunity, an option to be able to file bankruptcy if your income is greater than the threshold in a Chapter 7 bankruptcy. You know, one of the things that I like about bankruptcy, and it is that, believe it or not, it's a happy outcome. We can help people get a fresh start in their lives. And when they get that discharge, which is the wiping out of their debt from the court, meaning the case is complete, they're happy. We've taken the pressure off of them. There's no more, going month to month trying to figure out how I'm going to pay all these bills, paying one creditor while you're not paying another one during a certain month. It's stressful. And I've had people break down emotionally and become very, very, very tearful about having to go through the process. But at the end of the day, there's what they call light at the end of the tunnel. And that's really what bankruptcy is. It's a light at the end of the tunnel. I can go on and on about the different chapters, that we deal with and the minutiae of the bankruptcy, but the most important thing is this: know your rights. It's a federal law. Every year, about 1 million people file bankruptcy in the United States. So you're not the only person who's in that situation. If you were the only person in that situation, there would not be as many bankruptcy lawyers as there are in New Jersey. But we have a great deal of people who need help. And one of the things that we do is we help people by taking this pressure off of them. I want to see everyone in a position where they can go on with their lives, they're not being sued or pursued by creditors, and that they have the ability now to rebuild and restart their businesses, their careers, and everything else. So I do a lot of this work. I do it because I enjoy it. A little background on me: I started as a trial lawyer. I used to try cases, civil and criminal litigation. But I kind of got a little bit down on the whole trial process and the criminal process especially. So now I look for happy outcomes. No more divorces, no more criminal cases, things like real estate and bankruptcy. Believe it or not, at the end of the day, if I do my job correctly, people for the most part are happy. And that's what I try to do, make the clients happy. So I want to leave some time now for questions because it is a complicated subject. I would advise you not to file on your own, although you can in New Jersey and other states. I would advise you to at least talk to an attorney and get the facts about bankruptcy and understand the specifics of it. The chapters the different chapters are complicated, and there can be some confusion about, where I file and when, but all consultations with my office are free and they're also confidential. And I'm not revealing any names, but I have actually helped people in this chamber with these sort of problems in the past, and you would never know it because we don't talk about it. So if you do know somebody who's struggling financially, or you do know somebody who's behind on their mortgage payments, please have them contact me. I want to take some time now for questions if anybody has them.
Right. Just raise your hand if you want to ask a question, ask Gerald a question, and we'll call on you. And don't forget to unmute. I saw a couple of hands go up. Donna?
Jerry, are the ramifications different under a Chapter 7 as opposed to the Chapter 13
question.
on your credit?
Great question. Thank you. I should have talked about that. Thank you, Donna. In bankruptcy, it's going to have a negative impact on your credit for the next 7 to 10 years, whether you file a Chapter 7 or a Chapter 13. But if you file a Chapter 7 bankruptcy, you're pretty much done with the bankruptcy process within about 6 months depending, but usually it's about a 6-month process. A Chapter 13 is a 5-year process. While you're in bankruptcy itself, while your case is active, it's going to be very difficult for you to get new credit. We'll be able to get a car loan, we'll be able to get a mortgage, things like that. But once the case is over, I've had clients come back to me 2 years after a bankruptcy filing and be able to buy a house, and they will get car loans. Your credit will be more expensive when you get it. You won't pay the interest rate you see on TV where they say 0% financing for 60 months on a car. You'll probably pay 3 or 4%, or maybe higher than that. It all depends. But you will be able to get credit. You may be denied credit from some creditors, but other creditors will actually want to step in now because you can't file bankruptcy again for another 8 to 10 years. So you have that, they have that window now to restart your credit. Your credit score will go down about 200 points when you file bankruptcy. When the case is over, believe it or not, it comes back because your back-end debt ratio is now completely eliminated. You don't have $25,000 in credit card bills. So the answer is yes, it has a negative impact, but over time, it actually improves your credit score.
Great. Anybody else? Questions? Erika?
I have one. Oh, sorry. Go ahead, Erika.
Hey, good morning. Thanks, Gerald. Quick question for you. I had a client that has medical bills,
Yeah.
old medical bills. She's no longer hearing from the collection agency that they had been trained to. What is there like, at some point, does it just, I know it just doesn't go away, but what would you recommend for how to proceed with something like that?
Generally speaking, it's a decision that, she has to make based upon what the next step is.
Mhm.
Generally speaking, when a bill comes to, let's say, from a medical provider, the medical provider will try to send you an invoice, maybe 2 or 3. If you don't respond to that, the general process is they send it to a creditor collection agency, who then tries to collect it. If they can't collect it, that bill goes to an attorney, a collections attorney. And that attorney has 6 years to the date the bill was incurred to file a lawsuit.
Mhm.
So even though there might be a gap or a lag, there's still a 6-year window for them to act on that debt. If they get a judgment, they can do a lot of nasty things. They can put a lien on the person's house. They can levy on their bank account. They can try to do a levy on possessions or chattels, meaning have the sheriff come to the house and say, give us your car, give us your, your furniture, things like that. So there's a lot of bad things that can happen if you let it go. The best thing you can do, if it's one medical bill, is perhaps try to work out a payment arrangement, either with the collection agency or with the law firm. Sometimes they'll settle for 30-40% of what you owe. Sometimes you do a payment plan of a couple of years. But don't ignore it, because eventually it's still going to be on your credit, and it's also going to be something that they can after you for up to 6 years.
And is that 6 years from date of service or 6 years of invoice, or what is that date of statute?
Here's the date of service. So let's say, for example, I went to the doctor January 1st of this year. They'd have until January 1st of 2027 to file a suit.
Great, thank you.
You're welcome.
Dorothea, you had your hand.
Yes, I did. Thank you. Gerald, 2 quick questions. You said it was a credit issue, perhaps 7 to 10 years. Is that right?
That's right.
Okay. And that's from when the actual bankruptcy takes place? Like right? It's when that gets approved, I guess?
Yeah.
Okay. And then the other question I had was, is that the same if it's a corporate versus an individual?
Well, corporate bankruptcy is a little bit different, because there could be a corporate Chapter 7 where the corporation is saying we're out of business, we have no assets, we want to get all our bills wiped out and move on. Or there could be a Chapter 11 reorganization bankruptcy,
Okay.
which the corporation may elect to file if they have business, they think business is going to improve, and it's a lot more complicated. There's a creditors committee, and I don't want to talk about it here because it's really designed for bigger businesses.
Right.
If
Okay.
you know somebody who has a bigger business and is thinking about that, we can talk about that off the air, but it's a lot more complicated.
Got it. Thank you.
Anybody else? Let me switch. I got a second screen here. Anybody here? Questions for Gerald before we wrap up? No? Okay. Well, thank you very much, Gerald.
Oh, thank you guys for letting me talk this morning. It was a real pleasure. I appreciate it.
Yes, great information, important information, and it's nice to have you as a consistent attendee of this perk so people can access
It'll be
you.
9 years in March.
Wow. Yeah.
Yeah.
You know what? I think for me, it was actually, no, 8 years for me. So you're a year ahead of me. So Gerald, just don't forget to put your information in the chat so people know how to contact you via email or cell phone. And everybody, just a reminder that if you want to record the chat, there are 3 dots at the lower right-hand corner. You can click on that and save it to your computer so you can capture all the chat information before the end of the meeting. Just want to say next week, I just want to make an announcement. Next week's meeting is going to be with Tom Principe and Ann Dubon. Raise your hands, Don and Tom and Ann. They will be talking about the upcoming Lunch and Learn for our Small Business Advisory Council. They're just going to do a little teaser promo because we want to give you the information at the end of the month. But don't forget to tune in to hear what they have to say next week. Again, today's Lunch and Learn is sponsored by Center State Healthcare System. And thank you.